Hi, everybody. Hi. I just wanted to thank you so much for coming to the 35th annual Supreme Court preview here at William & Mary Law School. We're just thrilled to welcome you, whether you are here with us in person or if you are watching at home through Zoom. My name is Allie Orr-Larson, and I'm on the faculty here, and I'm also the director of the Institute of the Bill of Rights Law, and that's the institute that hosts the Supreme Court preview. I just have a couple thank yous and a couple logistics, and then our Dean, Ben Spencer, will kick off our event. First, a huge thank you to the team that put this together, Alicia Riley and Matt Hedrick, our event staff, and Whit Widener, our technology guru, I think that's his official title, and Adam Davis, a 3L and the president of the IBRL, the student president of the IBRL. These four people worked tirelessly behind the scenes to put this event together. It took a lot of work, and it couldn't have happened without them. So I'm very grateful. I also want to thank Neil Devins. Neil steered the ship of the IBRL for a long time, and I'm very grateful that he took me under his wing as an apprentice, which is a role I still cherish. So thank you, Neil, for all your guidance and advice. And last, I just want to thank our extraordinary panelists who come far and wide to Williamsburg every year in order to let us learn from them. And we have as they would say in Hollywood, an all-star cast. We have sort of all-stars from the bench and the bar and the academy and the Supreme Court beat. And this is just, you are in for such a treat. We're very excited. So logistics, if you're attending in person, we're in here tonight, but all day tomorrow we're in room 119, and room 120 will be the overflow room. There's some shuffling. There's a docket deep dive breakout group. But we'll show you where to go for that. If you are on Zoom, welcome. You also have a chance to ask questions of our panelists. After every panel, you can chat your question to Jake Blevins, a 2L student here, and then the moderator of the panel in person at the end will say, do we have any questions from the online audience? And Jake will ask your questions, not all of them, but some of them. I also wanted to make an important reminder that the Moot Court you're about to see is an academic exercise only. This has become important to emphasize, particularly in recent years. So the opinions that are expressed by the advocates or by the judges, they don't necessarily reflect their own views. It's just an academic exercise. We are all here to learn from each other. Don't FOIA us. Okay, so without further ado, I want to turn things over to Dean Spencer, the one and only, the law school dean, and also my friend. He's going to open things up.
Thank you, Allie. It's a pleasure to be here. As Allie said, I'm the dean of the law school. This is my third year, and this has been a wonderful experience. I think my first year, this event was entirely virtual. And then last year, we did have the opportunity to come together, and now we're approaching more normalcy. So this is really starting to feel good. Now, each September, the law school is absolutely thrilled to host the country's most preeminent scholars, judges, advocates, and Supreme Court journalists to preview what is in store for the coming Supreme Court term. Hosted by the Institute of Bill of Rights Law and its director, Allie Larson, this event is truly a highlight of the year for our community. Today marks the 35th Supreme Court preview, and it is set to be a blockbuster. Over the next 2 days, you will hear from the nation's leading Supreme Court experts, both about last year's seismic term and, importantly, what will come next in its wake. As is our tradition, we start each preview with a moot court, where talented advocates and mock justices, don't mock the justices, try out arguments for a prominent case on the court's docket. And this year, that case is an election law case, Moore versus Harper. Arising from North Carolina's efforts to draw new congressional maps in response to the 2020 census, in this case, petitioners invoke the independent state legislature doctrine, which is the idea that under the US Constitution, only the state legislature has the power to regulate federal elections without interference from state courts. So without further ado, we're going to kick off the 2022 Supreme Court preview. And to do that, I'm happy to hand things over to our Chief Justice this year, Joan Biskupic of CNN. Thank you.
All persons having business before the Honorable, the Supreme Court of the United States are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
Our mock court will now hear arguments in number 21-1271, Moore versus Harper. Mr. McCloud. We understand you're going to reserve 3 minutes.
Correct, Your Honor. Madam Chief Justice, and may it please the court. The question presented in this case is whether state courts can rewrite a state legislature's regulations governing the conduct of federal elections. The Constitution's answer is clear. The Elections Clause provides that the time, place, and manner of congressional elections, quote, shall be prescribed in each state by the legislature thereof. But in the decisions below, the North Carolina courts ran roughshod over the legislature's election plan and imposed an entirely different plan of their own devising. Constitutional text, tradition, and structure forbid that result. Start with the text. The Elections Clause assigns responsibility for federal elections to the legislature, not to the state as a whole or to the governor of the state, and certainly not to the judges of the state.
Can I ask you a question? What are the limits of that principle? How wedded do you really are how wedded are you really to the text? Because I mean, so is Smiley wrong?
No, Your Honor.
It's
Smiley.
the governor's involvement. What's the textual basis then for distinguishing the governor's involvement from the state court's involvement?
Your Honor, I think Smiley helps us because Smiley recognized that the word legislature was a word that at the time of the framing had a specific meaning. That's the representative body of the people. Now, the court, it's true, said in Smiley that the governor's veto was part of the legislative process in that state. And so the power that was being exercised by the governor was fundamentally a legislative power. That is certainly not the case here.
But just to be clear, the text says legislature, not legislative process. So your argument's really not a textual argument then, right?
My argument is a textual argument, Your Honor. We're focused on the text of the Elections Clause. We think that has to be taken seriously. And the text assigns power over federal elections to the legislature. Now, there are questions about the extent to which a legislature could assign some of that responsibility to other actors within the state. But however you define that term, it certainly cannot include the courts. What the courts here did was exercise judicial power in the traditional manner they always do.
If we're
The Constitution also assigns Congress the power to override a state legislature and doesn't say anything about this court. Are you saying that we lack the power to review any congressional act involving the same Elections Clause?
No, Your Honor, you certainly would have the power. And I want to clarify, although we think that state courts have a very limited role in review of decisions made under the Elections Clause, we fully agree that federal courts have the authority to review these decisions. So if there were a federal constitutional claim or some other federal law issue that arises like an issue under the Voting Rights Act, federal courts, of course.
I mean, Congress can write laws that supersede those of a state legislature, and those it has that power under our Constitution. I'm asking if Congress were to do that, say with HR 1, a bill that passed one house in the current session, is this court able to review that act? Because there's no text that says anything about the president or this court's involvement in Congress when it supersedes the state legislature.
Yes, Your Honor, because we don't read the Elections Clause as displacing the principle of judicial review in toto. It preserves judicial review of federal issues, which is fundamentally what this is, for federal courts. The question here is whether state courts can exercise the power that the Constitution assigns.
Great. But when it comes to issues of federal law, what possible basis is there distinguishing between federal and state courts? The Supremacy Clause doesn't say federal judges, it says all judges. And so does your argument suggest that state courts couldn't conclude that a state statute violates federal law?
No, they could. That's one of the roles that we think that state courts
Okay,
have.
because you just said federal courts, federal law. Well, I think your argument is federal law and that the federal courts part drops out, right? The North Carolina Supreme Court, if it wanted to, could say this plan violates the federal constitution, couldn't it?
It could, Your Honor. It could.
If the meaning of state law is ambiguous, who decides what it means?
I think
Court or federal court?
I think it depends, Your Honor. So as a general matter, we don't dispute the proposition that state laws are in the first instance to be interpreted by state courts. But as this court recognized in the Palm Beach County case and Bush versus Gore, there are circumstances when
This court didn't say anything in Bush versus Gore. 3 people said something in Bush versus Gore.
that's right, Your Honor. But Justice Rehnquist's opinion in Bush versus Gore recognized there are times when interpretation of state laws can trigger a federal constitutional question. So there could be circumstances where this court or another federal court is involved in the interpretation of the state law.
And how are you delimiting when there is a role for a state court to interpret state law or when it's a question for a federal court?
I can't draw that line. I think in every case, Your Honor, it's going to depend on the extent of the intrusion of the state courts into the legislative plan that the state legislature has adopted. And here we have a system where the state court has totally overridden the plan that the state legislature adopted. So however that line gets drawn in future cases, it does not include what happened here.
You said that
The state legislature can share its power. It did exactly that. Your North Carolina legislature did by saying there is a role for state courts to review our redistricting decisions. Why is there something wrong with that? The legislature said that.
Few responses, Your Honor. I think the provisions that you're referring to are best understood as procedural rules that don't impose any sort of substantive restriction on the ability of the legislature to redistrict or to impose time, place, manner restrictions on congressional redistricting. To the extent you think they are substantive, then I think that you could interpret that provision as applying only to state court litigations or to federal questions that arise in connection with state court review. So as I was just discussing, a state court could review a federal question that arises in connection with a state redistricting system. And so we think that's perfectly consistent with our position.
Can you return to the text of the election clause and point to the part of the clause that refers to federal courts?
Your Honor, it's not the clause itself, it's Article 3 in general that establishes the role for this court and for other federal courts.
So why can't state constitutions establish a role for their courts and their within their constitutional system, especially with respect to imposing requirements of fair and free elections?
Your Honor, because the power that's being exercised, the power to create a congressional district is a federal power. State courts don't have the authority to override the clear delegation that happened in the Constitution when the framers said that those decisions should be made by the state legislature.
Could you go back to the framers and talk about what they were actually saying? Was a discussion at the founding moment during the Constitutional Convention about separation of powers, or was it about federal or state role with respect to the time, place, and manner of elections?
So, Your Honor, the best evidence we have comes from the Committee of Detail, which was marking up the Pinckney Plan. And it's clear that in the original draft of the Pinckney Plan, the state as a whole would have had responsibility for deciding how to regulate congressional elections. In the course of those discussions, that language was changed from the state to the legislature of the state. So we think it's clear that there was an intentional decision on the part of the framers to single out a particular body. And that makes sense because the framers were concerned not just with ends, but with means. And when it came to the means of policymaking, they wanted to empower legislatures, state and federal, and not courts. What state legislatures do in this area is quintessentially policymaking. There is no role in that for the courts to override those policy decisions.
But just so we're clear, I mean, in some of your briefing, you say that the state legislature has the sole role subject to check only by Congress, but you don't really mean that because you've already acknowledged that there's a federal court carve out or a federal law carve out, right? So you don't really mean that the state legislature has sole responsibility subject to check only by Congress. You mean something less than that.
Your Honor, we mean subject to check by Congress and subject to check by federal courts or by state courts applying federal law.
And just to be clear, like the last piece of that really has nothing to do with the text of the elections clause.
Well, Your Honor, it goes back again to Article 3. We think Article 3 creates the presumption that there is judicial review available. We're not disputing that. The question is which body of the judiciary does the review? And here, the text of the elections clause cuts out any role that state courts could have on state constitutional issues.
Except, I think, to Justice Heytens' question, you acknowledged in response to his question, there is a state court role with respect to federal law. That's got nothing to do with Article 3, correct?
I think that Article 3 creates the ability to review federal legal questions
By
in
federal
a court.
courts, but by the courts that are created by Article 3. Article 3 has nothing to say about state courts, right?
That's correct, Your Honor. So I think the Supremacy Clause, also says that federal legal issues should presumptively be decided by federal courts. There is still a role that this court has recognized for state courts, though, to resolve some important federal legal issues. So we think that it's
Counsel.
Mr. McCloud, can I just ask, you're asking us to take a very dramatic step here, which could involve overturning other decisions. And I'm just wondering, is there anything in the North Carolina Supreme Court ruling that could be a more modest step? Now, granted, I know where you want to go, but I'm just asking, is there anything about that ruling where you think the state court did not properly interpret the state constitution that we should be aware of?
Your Honor, it's not an issue of interpreting the state constitution. I think if the court wanted to split the baby and take a more modest step, one option would be to say that although the court had the authority to review the constitutionality of this decision, it did not have the authority to totally rewrite the elections plan and impose its own plan. What happened here is that the North Carolina Superior Court essentially outsourced the decision about how these districts should look to a bunch of special masters and to a neuroscientist and some other professors. That does not resemble at all the process the framers thought of and the process that's embodied in the clause, the text of the elections clause.
Counsel, I think my question dovetails with the chief's. Would your theory of the case be any different if the North Carolina courts had relied on a more specific state constitutional provision and not one that was just, calling for free elections? You suggest some of that in your briefing, but I'd like to nail down if that's the case. And if so, how do we draw a line between what is specific enough and what's not?
Your Honor, our position would be the same regardless. It's at the fundamental basis is that there is no role for state courts to impose state constitutional restrictions on these districting decisions. What happened here is an especially egregious example because the provision was so vague and generic. It just says all elections should be free. And that's exactly the sort of concern the framers would have had.
So let me give you a hypo that I think illustrates just how extreme this could get. So right now, federal courts will tolerate population deviations of, this better than I would, 5 or 6%.
Correct.
Okay, so federal courts will tolerate a population deviation of 5 to 6%, but the state constitution says, look, we live in a world of computers. You can literally make districts that are at most 1 or 2 people off. So we think, and imagine the text of the state constitution says this, you can't be more than 10 people off. And the state court enforces that. In your view, that violates this clause that you're relying on.
Yes, Your Honor, because that's a restriction on the ability of the state legislature to decide how these districts should look.
So counsel, essentially what you're saying is that the framers wanted citizens to have no protection under their state constitution for their voting rights. So it essentially eliminated the role of any state constitutional protections for voters when it came to federal elections conducted usually at the same time in the exact same way as state elections going forward. Is that it? That they simply said, instead of the federal constitution being the floor and state constitutions allowing, more elaborate rights, there will be no more elaborate rights for you. You only get the basement of the federal constitution.
So I don't agree with that premise, Your Honor, for a couple of reasons. One is the clause still preserves a role for Congress to come in and to override state legislatures' decisions about districting. So if Congress thinks that what a state legislature has done is inappropriate and it doesn't give an appropriate voice to the people, they can come in. We still have the backdrop of federal court judicial review, as I was suggesting before. And then more fundamentally, a state legislature is representative. It's a responsive body to the people. And so,
can I just make sure I understand how your view works? So may a governor veto a redistricting plan that the legislature has come up with?
if the governor's veto is part of the legislative process in that state, then I think the answer under Smiley is yes.
Okay, so that we know the executive branch can be involved. What about if there's a claim that the state statute is ambiguous? Can the state courts resolve that question of statutory interpretation?
I think in most cases, yes, there could be difficult questions that arise.
I got it. So the state courts can be, and if there's a claim that it violates the federal constitution, the state court can adjudicate that too.
Correct.
So the only claim that the state, so both branches can be involved and the state courts can adjudicate state statutory claims and federal constitutional claims, but not state constitutional claims.
That's correct, John.
Okay, and the tie for that to the text of the elections clause is?
The tie is the clear delegation of federal power to state legislatures.
Well, it's not the word time and it's not the word place. So is it the word manner?
It's the word manner, yes.
It's definitely not time or place. You agree with that?
I agree with that.
How do we know the legislature is exercising legitimate or valid legislative power? Aren't legislatures a creature of the states and the state constitutions?
I think that's correct, Your Honor. And so if there were a question about whether an enactment by the legislature complied with rules like bicameralism and presentment, that could be a state law question.
Sure, it seems like your position is suggesting that a legislature can act and legislate in conflict with the state constitution, and we would still regard that legislative action as legitimate.
Yes, Your Honor, because what the state court or what the state legislature, is doing in this circumstance is exercising a federal power that has been delegated to it under the Constitution. I think a good way to think about this is if Congress passed a law, a federal law that regulated some federal issue, a state court could not come in and invalidate that law under its own state constitution. That would be inappropriate. And that's equivalent to what's happening here. A state court has come in and invalidated what is essentially a federal legal decision on the basis of this vague, abstract state court provision. And
How do we know that judicial review is not part of state legislative processes? What is it in the Constitution of North Carolina or anything else that tells us one way or the other whether judicial review is part of legislative processes or not?
well, Your Honor, I think the Constitution of North Carolina is clear on this because it creates three separate branches.
Well, but you
judicial
already told us
executive
that
is
the
also-
executive branch is
Right.
part of the legislative process. I don't understand.
Your Honor, I just to clarify my earlier answer, the executive is not part of the legislative process except in the limited scenario where a state court creates a right to veto legislation. Then there is some involvement of the governor in the legislative process.
But then constitutions give the courts the right to review and invalidate legislation. Why is that not part of the legislative process, given that in order for legislation to be valid and to go forth, it has to be declared valid by the courts if it's challenged, right? So why should that not be part and parcel of the legislative process?
Well, Your Honor, I think the problem with that position is it really does nullify the text of the elections clause. As I said before, the clause could have referred to the state as a whole making these decisions, but it delegated particular power to a particular body within the state. And I think that delegation has to be respected. It has to mean something. And under the position that you're articulating, it doesn't mean anything.
I don't understand how that's different from Article 1, Section 8 of the federal constitution. Delegate, it says Congress shall have power to do certain things. And you're acknowledging that there's an implicit judicial review power. Here we're talking about an explicit judicial review power in North Carolina law. I don't understand how you say that the one can exist, federal judicial review, but state judicial review can't exist under the circumstances of this case.
Your Honor, it goes back to the fact that that power that is being exercised by a state legislature is a federal power. It is not a power that the states had at the founding. It's a power that only exists because Congress gave it to them. And so the laws that they create are essentially regulations of federal legal issues.
But you agree, I mean, the elections clause refers to state legislatures and then it refers to Congress. When Congress makes election laws, I assume you think like they're subject to, veto by the president, override federal judicial review and all the rest. I mean, it says Congress can make or amend, but under the normal federal lawmaking process, right?
I agree, but I would say—
Why would you think that when they vested that, when they took that federal power, which we all agree has to go through the normal federal process, and they gave it to the state, we wouldn't think it has to go through the state lawmaking process, just like it would at the federal level?
Your Honor, because the power that was given was the power of the legislature to make regulations.
So too with Congress, but it has to do it subject to veto by the president, review by this court. I don't understand what's different on the state level.
Well, Your Honor, what this court has said in prior decisions like Smiley and Hildebrand is that the power that's conferred in the elections clause is a legislative power. And so the question here is really whether the North Carolina courts were exercising judicial power or legislative power when they overrode the plan here. I don't think there's any dispute that it was fundamentally a judicial act. They were looking at facts, they were looking at laws, applying facts to law, and coming up with a judicial decision.
Mr. McCloud, in terms of, let me just ask one thing on when I'm thinking of our precedent. Well, how would your argument handle redistricting commissions? What if the legislature ended up not happy with what a commission came up with? Would that be the end of commissions as we understand it? How is this going to intersect with with the Arizona redistricting case and even Rucho's sort of promise of something at the state level to get at extreme gerrymanders.
Madam Chief Justice, you don't need to overrule the Arizona case in order to rule for us in this case. For this reason, there was a lot of disagreement, obviously, between the majority and the dissent about the meaning of the elections clause, but everyone was on the same page when it came to the fact that the power being exercised was a legislative power. And as I was saying before, there's no question that what the North Carolina courts here did was judicial, not legislative. Now, having said all that, if you'd like to overrule Arizona, be my guest. We think that it's an egregiously wrong decision for all of the reasons the Chief Justice Roberts, said in his dissenting opinion.
Can I go back to the committee of detail, the point that you're distinguishing between the state and the state legislature in that particular change? Now, note, it didn't change it to state legislature and executive. It said state legislature. So what's the justification for the argument that state legislature now suddenly includes executive? Because even though they did not mention that specifically, in the way that would be consistent with the argument that state doesn't refer to state legislature, courts, and executive as well.
Your Honor, I think the court addressed that issue in Smiley when it said there are some states where the governor's veto power is considered an aspect of the legislature.
I'm talking about the specific language in the committee of detail, that discussion, that back and forth, the inference that you're drawing from that decision to go from state to state. Is there any evidence with respect to what the actors were saying at the time in their shift from state legislature to state that they meant to include the executive, but exclude the judiciary from that idea?
No, Your Honor, there's no evidence that's contemporaneous with the committee of detail. The best historical evidence we have is from Massachusetts in 1820, when Massachusetts considered an amendment to their constitution that would have required district by district elections for congressional representatives. And Justice Story and Daniel Webster both said, what are you doing? We can't do this. It would be unconstitutional under the elections clause. So that's a strong historical basis to show that this clause was understood the exact same way we're articulating.
But that's because it would remove all power from the legislature. We're talking here about the limits of the exercise of power by the North Carolina legislature. And I'm having difficulty, I'll confess, grasping that the North Carolina legislature can act beyond the boundaries of the Constitution that created it. And my question is, help me through that.
Tell me.
Your Honor, the North Carolina court was not acting beyond the boundaries of the North Carolina court constitution. It's acting beyond the boundaries of the federal constitution.
But I'm struggling with that because ultimately the North Carolina legislature is a creature of state law. So to the extent it's acting at all, it's acting within the parameters of powers that have been granted to it by the state constitution.
And we don't dispute that there might be some state constitutional restrictions on what a legislature could do. So for example, if North Carolina required a supermajority vote in order to pass a redistricting plan, that's something that it can do. And we think that that's perfectly consistent
But
with
the North Carolina Constitution required a supermajority vote. Do you think that? Or is that a restriction on this roving federal power of the state legislature to do whatever it wants?
No, Your Honor, that would be a procedural regulation of the sort that we think is appropriate. The problem here is there was a substantive limitation imposed on the ability of the legislature to create the districting plan. And that's inconsistent with the text, with the history, and with the structure.
But there's also a substantive limitation imposed when a governor vetoes a redistricting plan.
Well, the difference, Your Honor, is that in the veto scenario, the legislature can go back and override the veto and enact the same plan. Here, North Carolina doesn't have the option.
Well, they can do that because state law says they can do that.
Right.
What if state law says you can't override gubernatorial vetoes?
So that would be sort of an extreme version of Smiley, and I would say that's unconstitutional.
All right, so let me ask you this. So given the background assumption that I think you've acknowledged about sort of judicial review generally in 1787, why isn't the perfectly sensible interpretation of the elections clause that it simply means to vest in the legislature sort of in the first instance the right to prescribe rules with respect to federal elections, as opposed to the town council or the sheriff or whatever, but not to the exclusion of ordinary Marbury-style judicial review?
Your Honor, I don't think that's a plausible inference from the text. It's clear Congress thought of the backstop, and the backstop they identified is the federal Congress. As I was saying before, that makes a lot of sense because Congress viewed questions of districting as fundamentally political and policy-making decisions. And
I guess the reason I'm having a difficulty with this is that you've already conceded that federal courts can get involved. They're not mentioned in the elections clause. You've already conceded that state courts can get involved so long as they're adjudicating questions of federal law. That's not mentioned in the elections clause.
Well, as to the federal courts, they are mentioned in other aspects of the Constitution. And so I think that has to be read together with the elections clause. And I understand Your Honor's concern. It sounds like we're cutting out an important role for state courts, but in our view, that's not correct. There are plenty of backstops here to prevent the sort of abuses that people have suggested that our position would lead to.
You
Could
agree
you
though
talk
that,
more about that? Because I don't understand. We all said that state Supreme Courts could protect against extreme gerrymandering just a couple of years ago. But I don't see how that's possible with your position.
Your Honor, I think it's right as to gerrymandering issues. A state court could not strike down a congressional redistricting on partisan gerrymandering grounds. But this court addressed.
We said they could.
Well, this court addressed that issue in Rucho when it said that simply because someone identifies a problem and thinks that the judiciary can solve it doesn't mean that the judiciary actually is empowered to solve the problem. And I would submit the same is true here. I understand that many people think that partisan gerrymandering is bad and is an issue that should be dealt with. But the elections clause is clear that if that is going to be resolved, it must be by state legislatures or by the federal Congress.
Do you have a fallback position? In other words, if we think you're wrong and there is a role for state courts, do you have a fallback position that there can be state court rulings that are so extreme or intrusive that they violate the elections clause, but only in the most extreme circumstances, or is yours just an all or nothing?
We do have fallback, Your Honor. The fallback would be one I suggested earlier, which is you could take the position that state courts could invalidate a redistricting plan based on a state court constitutional provision, but they cannot replace that plan with their own.
But then what happens if, I mean, this is not really that hypothetical. What then happens if the legislature just doesn't pass another plan?
Well, then it's a problem for the legislature. It's ultimately their responsibility to pass a new plan.
No, but what's the status quo? So a court says you can't use this plan. The legislature doesn't pass a plan. The court can't impose a plan. There's an election, which, by the way, federal law does require the election to happen. So it's election day. There has to be an election. What map do we use in that situation?
If the legislature hasn't passed a map, there is no map. And I don't think that's a likely scenario because the legislature
There's no map.
What's happening right now?
Yeah, so there would be no election. And it would be just at-large elections in which everybody would be elected at large from the state.
I mean, I suppose you could default back to the last map that the legislature passed, but fundamentally,
which was declared illegal or invalid by the court.
The prior map before that, but fundamentally,
which
it's
might be
map.
malapportioned because we've had shifts in population. And one person, one vote says they have to be apportioned correctly.
And Your Honor, that's why I think that it's clear the legislature would come up with a new plan because it's their responsibility.
But I have one other question following up on Justice Wall's one. How do we know when a state court has done something that's so rogue or so extreme? What kind of test would we write?
Your Honor, I think you would write a fairly simple opinion that says it's up to the legislature to make these decisions. If the state court is applying a state constitutional provision, that's invalid. There is no basis for that sort of review.
could the, well, I have two questions, totally related. Related to this one, I would say, could then the state court say, sequester the legislature and sort of like, you know, jail them until they pass a new map or something? They do that. I mean, that way they're enforcing their federal, you know, obligation to go forward with the election, right?
There might be due process issues that were raised. You know, I think the fundamental issue is that it's up to the state to make these decisions.
If the, you know, you agree though, that the state court can oversee the state legislature, right? It's maps for the state legislature, right?
Correct.
Right. So, so they could apply the same vague term of, you know, fair elections to the state legislative map, right?
That's right. But that's a problem for the North Carolina courts to deal with on the state side.
Thank you, Mr. McCloud.
Thank you, Your Honor.
Ms. Ratner.
Ms. Chief Justice, and may it please the court, there are two independent reasons to affirm. First, you should reject petitioner's independent state legislature theory. We're happy to agree that when the Constitution says by the legislature, that means the North Carolina General Assembly, but it doesn't mean the General Assembly acting in a vacuum. It means the North Carolina General Assembly acting within the context of the normal lawmaking process, which includes both a governor's veto and judicial review. That's exactly the meaning that is applied to the word Congress in the second half of the same clause. Second, even if the General Assembly alone has the power, then there's no federal prohibition on delegating that power. And that's exactly what we have here. The General Assembly set out precisely when and how a court should impose interim maps. Again, we think either of those is sufficient. By contrast, to side for petitioners here, you would have to find that a legislature means a free-floating legislature, and there is some sort of federal non-delegation principle, and that non-delegation principle is violated here. You'd have to walk back what this court said in Rucho, that even though federal courts aren't policing partisan gerrymandering, state courts can. You'd have to overturn Smiley and Hildebrandt, or at least reject their reasoning. You'd have to overturn Arizona independent redistricting and reject a proposition that both the majority and the dissent relied on. And you'd have to embrace a messy two-tiered electoral system with different rules for state and federal races.
All right, so can I ask you a question? I was pressing your adversary on the text of the elections clause, and I'll just do the same with you. I mean, you are asking us to read something into it, right? I mean, it does say legislature, and it does say, in effect, subject to check only by Congress. And so you are asking us to read in some stuff, right?
We're asking you to read the word legislature the same way you read the word Congress in the second half of the same clause. And everyone agrees that when it says Congress may at times by law make or alter such regulations, that means Congress subject to presidential veto and judicial review.
One textual difference, I think, and you can tell me if I'm wrong about this, is that the first half of the clause says state legislature subject to check by Congress. The second half doesn't say Congress subject to check by blank. Right, so there is a backup, as your adversary says, there's a backup with respect to state legislatures, but there is no backup with respect to Congress, at least explicitly stated.
There is a backup. I don't think that affects how we conceive of the word Congress or legislature when read in context. And if there's any different inference to be, if there's any inference to be drawn from the backup, I think it's exactly the opposite. This provision shows that there wasn't full trust in state legislatures. State legislatures were given a special constraint, and that to read out of that at the same time, the founders wanted state legislatures to sort of act free of other constraints, I think it's a pretty difficult inference to draw.
So you don't think that the specification of one constraint implicitly denies the existence of others? I mean, that's not a crazy interpretive principle, is it?
I think in a different context, it might be not be crazy, but here I do think, frankly, it is a little bit crazy. When we read the word, when we say, when we're talking about a legislature throughout the Constitution, when we're talking about Congress or a legislature, if we're talking about that related to lawmaking, the lawmaking power, then I think the assumption throughout the Constitution is that that's bounded by, again, executive veto and judicial review. We see that, as was already alluded to by Justice Crocker in Article 1, Section 8. We see that in this very clause.
Do we have any examples of judicial review of legislative decisions with respect to congressional districts from early in American history, say around the founding, after the perhaps 1800 census or the 1790 census? I don't know if they had a census then, but the 1800 census, in which the courts stepped in to check legislatures with respect to drawing district lines?
So I'm not sure the earliest example of judicial review, but let me give you a piece of founding era history that I think is really critical here, and that's the Articles of Confederation. Article 5 had almost the same text with respect to legislative authority. It said, delegates shall be appointed in such manner as the legislature of each state shall direct. And after that, the vast majority of state constitutions regulated federal elections in the period between the Articles of Confederation and the Constitutional Convention. So then we get to the Constitutional Convention, and the framers adopt basically the exact same formulation, knowing that that had already been interpreted as consistent with state regulation of federal elections. So there's almost, if this were a statutory interpretation context, we think of that as a ratification or reenactment canon.
Or
I think
considered a failure, the Articles of Confederation. Congress wanted to do exactly the opposite of that ill-fated project. I mean, to say this is too complicated. Let's make it very clear. Let's give the authority to the legislature. provincial assemblies or colonial assemblies, we don't know, have any history of judicial review of their lines. Parliament is not subject to judicial review when it draws its districts. Why would they come up with this innovation here to undermine the sovereignty of the states that they were so concerned about protecting?
I think judicial review by state courts was not an innovation at that time. Everybody accepts, and the U article is a good explanation of this, that the framers accepted that state courts reviewed state statutes consistent with state constitutions. And my point is, by repeating that same language, it would have been pretty remarkable for the founders to have expected that, in fact, they were creating some special legislature separate and apart from the ordinary system. I think if ever there's a dog that didn't bark situation, this is a provision that was extensively debated. This is a provision that was the subject of 3 Federalist papers, an enormous amount of data at the state ratification conventions as well. And nobody ever suggested that in this one particular context, state legislatures would not be bound by ordinary state constitutional provisions. What about a state Supreme Court gone rogue? A state Supreme Court decision that unwound a legislative decision in a way that was completely unhinged or untethered from the language of the Constitution. What's the check there? Shouldn't sort of the default or the tie go to the legislature?
You know, Your Honor, I think for 230 years of this court's history, it has not been worried about stepping in to review when it believes that state courts have taken an inappropriate view of state laws and state constitutions.
Can we do that? Can we review? Can we hold that the state court, the state Supreme Court, has incorrectly applied the state constitution?
I think that the answer is no. Could the court believe that that is a principle embedded in the elections clause and create some sort of special circumstance as suggested by Justice Rehnquist's opinion? You know, possibly, but I think that's going to get the court into an extremely
Can I just be
significant.
clear then on what that means? So let's just take some state constitutional provision that's incredibly vague in general. You know, we have to have free and fair elections in our state. And the state Supreme Court writes an opinion that basically reads like the election code. You got to show up in the following hours. Here are your windows. We're not going to let you have ballot harvesting, intra-district voting, all the rest. And maybe they leave a little bit of power to the legislature. You can decide what kind of Scantron sheets you want and, you know, whether they're number 2 pencils. But basically, like, look, we'll just lay it out for you. Here are the rules. That strikes me as really a problem. I mean, and there's no way then that the legislature has actually come up with the time, place, and manner of the election. And if that's what I'm worried about, like, do you have anything that can give me comfort about that?
Well, the first thing I can give you comfort is that this type of review of state court decisions, again, has not been done for 230 years of this nation's history. The second thing I can give you comfort on is if the court wanted to put a guardrail here, it could consider overturning Arizona independent redistricting and have some sort of circumstance in which the legislature cannot be, in the Chief Justice's words, supplanted rather than supplemented. But this case is a far cry from it. And importantly, petitioner's theory is a far cry from that. Petitioner is saying there can be no constitutional constraint at all. So if that case arose, you could consider something like the Arizona decision, but I don't think that's the issue here.
Counsel, we've been talking about the elections clause, which this case is actually about, but should we be concerned about any implications of the petitioner's argument for the electors clause?
You know, I think probably they run in tandem. I don't see a great textual distinction for construing one or the other. You know, the implications that I would encourage the court to be concerned about are the creation of a 2-tiered electoral system, which means that all of these provisions about voter ID, voter registration, absentee ballots, anything like that, if state constitutions can control only state elections, then all of a sudden there will be different rules for state and federal elections conducted within the same state. The last time that was threatened after this court's decision on the Voting Rights Act, the 26th Amendment was passed at record speed so that we could bring state and federal elections back in line. And so,
a question about your delegation theory. So before the 17th Amendment, to the best of your knowledge, did any state legislature purport to delegate its power to pick United States senators to like some third party?
I
I do not know the answer to that question.
I was just trying to think of provisions of the federal constitution that refer to state legislatures specifically, right?
So to be clear with that provision, again, if you look at this court's decision in Smiley, it really goes through between Smiley and Hawk and says there are different provisions of the Constitution, some that talk about legislatures, some are talking about the legislature in its lawmaking function, and some are talking about a legislature doing other things. Its electoral function in the context of Senate, or its ratifying function, its sort of qualifications assessing function. But it's pretty clear we're talking about in its lawmaking function. The verbs or the actions used in the clause are to prescribe, to regulate. Those are areas that the Constitution uses elsewhere to mean lawmaking. And so that's where Smiley says when you're acting in your lawmaking function, you are bound to enact laws in the manner in which the Constitution of the state has provided.
To follow up on a question I asked your friend on the other side, you concede this is a manner issue. I mean, it strikes me as you could argue that the time, place, and manner clause has literally nothing to do with this question because it's definitely not time, it's definitely not place. But I gather the tenor of your remarks is you do concede this is a regulation of the manner redistricting? I think redistricting has generally been treated as a manner. And as this court knows from its simultaneous Section 2 Voting Rights Act litigation there, redistricting is being considered as a procedure. And so I think we're not contesting that issue here.
So what are the limits then of your principle? I mean, is there any core that the state legislature can't delegate? Does it have to, sort of do every last little thing?
Well, our position is in favor of the state legislature's ability to delegate. I think it's petitioner's position that comes into some problems there, right? So if you were to think that the legislature is not bounded by state constitutional review, then we think the legislature here has still delegated that function to the court in this instance. And I think that you would have to find not only that there's this sort of independent state legislature notion, but also that there's some sort of federal non-delegation principle that prohibits the application of the specific North Carolina law here, which says the court may impose an interim districting plan. And I don't know where that non-delegation principle would come from. It doesn't seem to me that it would come from any federal non-delegation principle, which is bound up in both separation of powers and the vesting laws. And so you'd be imposing, I guess, a federal rule that a state has to comply with the same principles because of the state's own separation of powers, perhaps filtered through the elections clause. And frankly, it's hard for me even to spin out that theory. And that's what you'd be grappling with.
Can I tell you what's really bothering me though? And I don't even know the right way to think about it or frame it, but if Congress were doing this, it would be doing it subject only to the federal constitution. It takes this power, I think your opponent called it a plenary power, but whatever, and hands it off to the state legislature. And it seems odd then that the founders would have wanted that power to be subject to state constitutions. It seems like they would have wanted the state legislature to have the same power that Congress would have had if it had been acting in the first instance. So it seems odd to think that like these state constitutions can place all these limits on the state legislature. I mean, I grant you it's not a sort of textual argument so much as it just is like, it's just very odd structurally to think that states can do this.
Yeah, Justice Wall, I think that's wrong for a couple of reasons. The first is that, again, even if the federal constitution is allowing this to be an area of state law, contrary to what petitioners have argued, it's not actually federal law that states are making when they are enacting time, place, and manner restrictions. If there's a state law about the time of elections, that can't be challenged in federal court as under federal question jurisdiction or something like this. Those are still state laws, and so they go through the state process. I think the other reason that it's not
districting is different. I agree with you. Like, imagine hypothetically the federal government didn't exist, and the state would still have to have elections, and state legislatures would set the time of those elections. They'd decide what ballots you use. But the only reason a state gets to draw a congressional district is because they are given that. I mean, I understand we normally have this sense that states can do anything they want unless the federal law says they can't. But this strikes me as an exception for the reason Justice Wall said. Like, if the federal government didn't exist, states don't get to draw congressional districts. So the power they exercise when drawing congressional districts has to be a federal power, doesn't it?
Again, no, I think when they draw that congressional district and it's challenged, how you construe a provision in that law or something like that, that's still a state law question. And I don't think this court federalizes any time, place, and manner restrictions. And of course, the same would be true whether it's a redistricting question or something else. The court hasn't drawn those different lines here. And again, beyond this, we have to be thinking about what are the framers' assumptions here when they're using these words. They're operating at a time when judicial review of state laws by state courts was established, and they used the same sort of word, the general pointing to the lawmaking power that they used for federal Congress as
Follow up
well.
on that. I mean, could Congress, regardless of what's in the North Carolina Constitution, impose the same plan that the North Carolina General Assembly passed?
Yes. And that would be a federal.
That show that it doesn't really matter what's in the state constitution or what the state Supreme Court says?
It does matter. That would be a federal law at that point. If Congress imposed it, it would be a federal law that had to go through the federal lawmaking process and all the checks therein. And again, I think in my earlier answer to Justice Newsom is, if anything, we should think of the congressional check as showing the concern about state legislatures here, that there wasn't an idea to try to give extra, sort of special treatment where, unlike every other area in which state legislatures make laws, they get sort of a special free-for-all pass in the elections context. It was quite the opposite.
Can we go back to the dog not barking? It seemed like the dog barked a little bit, and it kind of goes back to what your co-counselor mentioned earlier in terms of the choice to shift from state legislature to state, right? What is the meaning of that choice? Is it just a stylistic issue? Or how would you respond to the counselor's point that has major import?
Mm-hmm.
That is a decision to essentially take this out of the court's hands.
So I think the best way to understand why the framers specified by the legislature is because otherwise it wouldn't have been clear what actor of the state or what process in the state.
But don't we have a Republican form of government clause that refers to the United States? So it seems like the framers were comfortable using language that doesn't refer to specific institutions in other parts of the Constitution. Why should we assume that they would have been comfortable if for not they wanted to place this power solely within the legislature?
So again, at the time of the framing, there were many election regulations and decisions done by the local board, the sheriff. And if this provision simply said prescribed in each state, I think there would have been a real question whether time, place, and manner rules had to be set by the state legislature and the state lawmaking process, or whether they could just be picked locally. It didn't matter as long as some actor within the state did that. And so I don't think this is superfluity here. This is important to ensure that we go to the legislative process, just like in the latter half, there's specification of Congress and not just the federal government, because if the federal government wants to change it, it too has to go through the lawmaking process.
Well, it sounds like you're imposing a non-delegation requirement then, right? Because local governments only act through authority granted by the state. And so at least that's the way that this court has described local government power before. And so if you're saying that the framers cared that it was the state that was doing it, I don't know, I see sort of a disconnect there. Like why do the framers care about whether local governments are doing something or the state legislature is doing it? And if they do care that the state legislature is doing it, then what kind of lines do we draw around that process to make sure that that's what's happening, that it's the state legislature?
To be clear, I don't mean to suggest that the state cannot delegate to local governments. What I mean is, we're dealing with the framing of the Constitution and a pretty vague default that is occurring at the moment, right? Sheriffs making rules in that town, maybe a board in another town. And what the Constitution does is it puts this lawmaking power into the lawmaking process at the state level. Now, could that legislature then turn around and say, the state boards are going to set, the hours polls are open? Of course. Or the local boards will set that. Of course, they can go ahead and send it right back to the sheriffs. But the Constitution was at least setting a default there. And I think that's why it's important to say.
Then that clause if the state constitution said, the sheriff shall draw the boundaries of the electoral districts, the federal election clause is preempting that. Is that what you're saying?
So I think there might be some questions if the legislature is cut out entirely under the court's decision in Arizona independent redistricting, and there could be a debate on another day about, again, whether the legislature can be entirely supplanted. But I don't think that debate matters here for today. The point is that the state constitutional provisions control, and that whether there are some provisions that would or would not pass muster is really not the central point. The central point is, if there are, under petitioner's theory, crystal clear provisions of the state constitution that says, the polls must be open for 2 hours at least 2 hours after the workday ends, that would not apply in petitioner's view to federal elections.
That's not the problem. I mean, what the real look, we all know what's going on. The real problem is you have state Supreme Courts interpreting vague, not specific, but vague constitutional provisions in order to change electoral rules in a way that sure makes them look like they're acting like legislators rather than courts. And I'm not saying this state Supreme Court is like that, but I'm not saying it's not. And so, like, if that's what's really bothering me, like, I hear you to be saying tough, like there's just nothing that there is no kind of guardrail or rule that we can set up that guards against that case.
I think that's right, Justice Wall. I mean, we could talk and come up with some outer boundaries, but the basic rule is this is a state law question left to the state courts. And unless we think that the state courts here have gone completely off the rails with vague provisions, I'd remind the court, and just a couple of years ago, there were very similar sounding equal protection clauses and First Amendment provisions that 4 justices on this court thought had a partisan gerrymandering ban. So these justices of the North Carolina court shouldn't be thought of as acting outside the pale. And the free elections provision that I think seems to be giving folks some heartburn, if you look at how it was construed by the court below, it was historically and for a long time in North Carolina understood as a specific ban on malapportionment. If things like an equal protection clause can arguably contain a partisan gerrymandering ban, then I'd certainly think a specific constitutional provision about malapportionment would as well. And that's why I think the court starts to get into a little bit of trouble when it starts second guessing state courts on state law issues. They may not apply the exact same textualism that this court does. They may have different histories or different approaches to construing that text.
Can I pitch you to a bit of a crazy idea, but it's something that's coming to mind while we're having this conversation. So when we think about the response to English tyranny that's occurring in the 18th century, and one of the responses and the concerns was about boroughs, rotten boroughs, right? And how are rotten boroughs created? They're created by the king. The king has full authority through prerogative to establish these rotten boroughs, right? Some checks were imposed, but a lot of authority with respect to these rotten boroughs. Those are kind of the equivalent of districts in my mind, right? And you can imagine in terms of the state or the frames of the Constitution, they seek to avoid anybody but the legislature, where there's a lot of faith that would be the representative body that would act fairly, that the legislature should be given this power exclusively, and to avoid sort of this tyrannical exercise of power by the king. And by extension, it ultimately excludes the courts as well. Does that theory kind of make sense, or what would be your counter to that theory?
If I'm understanding the theory correctly, we would expect, if that was the concern, to see either some indication in the text. And the text, again, the other side agrees here that the legislature at least encompasses review for federal unconstitutional provisions and review by a governor for a veto. And I would think
I agree. Smiley would be wrong
under Hildebrandt, right? This would all have to be wrong. And I think, I don't see an indication in the text for that, unless you're going to take the most dramatic view that undermines at least 3 of this court's decisions. And I don't see anything in the history supporting it either. I think the much more compelling view of the history is that more or less the framers stuck with what they'd had before in this particular instance. And that's made even clearer if we look right after the Constitutional Convention. 7 of the first 8 constitutions, state constitutions post-Constitutional Convention, contained some sort of restriction on federal elections. And so if we're thinking about sort of liquidating the meaning of the clause, that's the most relevant time at which to look. And so that's why I think... Sorry,
Could the
North Carolina General Assembly enact a law providing that redistricting would be done exclusively by the state Supreme Court?
Could they do that under North Carolina law? No. Could they do that? Would that be a federal? Right.
Fill in the blank. Could a generic state enact a law providing that the state Supreme Court would have exclusive responsibility for drawing districts?
So I think that there is no federal non-delegation principle that would control in that circumstance. And so I would say yes. However, if this court believes that there would be some sort of, if that's of some concern, then I don't think you can get to a non-delegation principle that flows from the federal government and sort of into the state constitution any more specific than the federal non-delegation principle, which at this point probably involves something like an intelligible principle. And so certainly, even if you wanted to apply some more stringent non-delegation rule, that test would be met here. There are specific standards in the North Carolina
Backing us a
code.
bit into though an all or nothing proposition. And if we can't say anything about, if we think that there might be some sort of abstract provision here that wasn't properly interpreted, or we think that the state court went too far, we can't do anything about it is basically what you're saying. And we really have to confront the largest question here.
I think you should confront the largest question here, because the all or nothing provision I'm talking about is not anything surprising or new to the court. The provision I'm talking about is that state courts are the primary arbiters of state law.
I guess I want to push back a little bit, just thinking out loud, which is dangerous. But I mean, analogizing to another area, is it really true that for 230 years, we've never sort of looked at the substance of state law as a federal constitutional matter? What about cases like Bowie versus the city of Columbia, South Carolina? Like there, didn't we really look through and say, no, too wacky? And that violates the due process clause or some such. Like, why not similar principle here, a meet in the middle, Chief Justice Biskupic kind of solution?
There have been very small occasional examples like Bowie. I think arguably Bowie is probably confined to a particular context. But even putting that aside, for the court to federalize state election questions here, I do think would be an incredible difference in kind, a difference in quantity by hard even to guess from something like Bowie, right? It would mean that every time there's a fight about one of these state constitutional provisions, it's federal courts that get to decide, well, that state court was, in the ballpark, or we thought that state court went a little too far.
And so I don't remember the specifics of Bowie well enough, but didn't we say in Bowie something like that it was so surprising by reference to what had pre-existed it or something, the state's interpretation of that statute? Why not something like that here? This was just so out of the ballpark.
Yeah, again, I think that where the court has carved out essentially federalized state questions have been really largely in a couple discrete areas that have involved effectively state court resistance to federal principles, like typically in those involving civil rights issues and the like. And so I think the court should be extremely reluctant for now, 230 years later, to create this as another sort of federal enclave of review of state law. And unlike some of those other areas which have more or less faded away, this is not an area that is going to fade away. This is an area that is going to grow. And so effectively the narrative from petitioner's side is, this can't be, this is a transfer of power from state legislatures to state courts. But what they're asking for is really a transfer of power from state courts to federal courts.
So can we talk about sort of transfers of power and judicial role here? And one of the things I'm concerned about in particular was the decision by the North Carolina Supreme Court to draw a new map. That does seem to be an exercise of legislative power as opposed to judicial power. Judicial power would strike down that map, and that would be the end of what the judiciary should do. But the judiciary did not stop there. The judiciary wrote its own maps, and the election would have to occur under the map that the judiciary drew. Now, why isn't a solution that stops short of giving the judiciary that power sufficient? Why shouldn't we just say, judiciary, you do have a role, but it's a specific role to invalidate the plan, but you cannot draw new plans?
So to be clear, this is a remedial power. It's not a sort of substantive power in the first instance. And it's a remedial power that this unanimous court in a decision by Justice Scalia and Grow said, of course, when there is a constitutional violation and we need a remedy, that the state court can step in and draw that map. And so I think if you want to add to the list of things that the court would have to overturn, you can throw Grow on there as well. And just to finish that is
Finish your sentence, right?
okay.
Yeah.
Thank you very much, Ratner. In addition, it happens all the time that there is impasse litigation or things like that, and courts have to step in to draw maps. That's just all at the first level theory. At the delegation theory as well, the legislature specifically said that these are circumstances under which a court should draw a map and how long that map should be in place for. Thank you.
Thank you. Mr. McCloud, you have 3 minutes.
Thank you, Your Honor. Just a few points. The first is that there is nothing crazy about enforcing the Constitution as it is written. What would be unprecedented and really unreasonable would be to let state courts usurp authority that the federal Constitution clearly gives to state legislatures. I heard my colleague on the other side say that if a legislature is entirely supplanted, that would be a problem. That is precisely what happened in this case. There was no role left for the North Carolina legislature in the districting process here.
But just one thing, your friend said that the same principle would apply to the electors clause. Do you agree that the legislature would also have unilateral power over appointing electors for the president?
So I don't agree it would be unilateral power. There is a textual difference between the two clauses. The presidential electors clause says that electors are selected in the manner that the state legislature may prescribe. And here we have a shall prescribe. I don't think that's a significant difference, but the bottom line for your question is this is not going to lead to a flood of fake electors or anything like that. There is a congressional backstop. Congress controls the time that elections occur. If there were a state court or a state legislature that tried to, after the fact, change the way that the electors were accounted for, that would be, I think, an equal protection and due process problem that could be resolved in federal court.
Can't we rely on the fact that there's a congressional backstop here too? Like if the state court does something that seems so, left field, Congress can step in. And so why should we be so worried that the state courts are doing something that the state legislature, wouldn't want them to do?
Well, Your Honor, I think that just points out the absurdity of respondents' positions for the reasons Justice Wall said. You're leading to a situation where a state court can do whatever it wants, and then Congress can reenact the very same provision, even though a state court has said it was unconstitutional. So I think what that shows is Congress wanted to concentrate control of these issues in federal hands, in federal legislatures, and in federal courts.
So can I just clarify? I just want to understand your position. State courts have a role with respect to time, place, and manner of elections with respect to enforcing federal law, right?
Correct.
Even though the electors clause or the elections clause says nothing about courts.
Correct, because we think that these are fundamentally federal powers that are being exercised. And so we don't dispute the proposition there can be federal constitutional review either in state court or in federal court.
But okay, sorry, just to get back to earlier, you predicated that view on Article 3, but state courts pre-existed Article 3 and presumably could have and would have, but the Constitution would have been striking things down as a sort of violative of whatever federal law there was. And so the state court's role with respect to federal law just doesn't really have anything to do with Article 3. That seems to me the piece of your argument that just seems like flat made up. State courts, federal law. Federal courts I kind of get the Article 3 tie-in, but state courts with respect to federal law, I don't understand.
I see my time is up. Thank you.
Well, all right. So thank you to Luke McCloud and Morgan Ratner. Excellent, excellent arguments. You actually felt like the real thing when we're just fake. We're now going to deliberate in our true fake educational way for about 15 minutes, Allie, about 15 minutes, and we'll come back to the bench and announce the decision.
That might be a little stuck in here. Go out that way, right?
Yeah, maybe go out that way, right? Okay.
Got it?
Yeah.
Right.
Sorry.
If everybody can take their seats, if everybody can take their seats, I believe the court, the pretend court, the non-real court has reached a verdict.
Well, the reason we always like to stress so much how this is pretend, and the way to demonstrate it is to give you the presents. So, which you would never get from the real chief in the court. Anyway, you two are great. Here they are from actually all of, you can come up and get it. We truly did spend the first 5 minutes talking about how great the arguments were. And as everybody knows, we don't vote our personal preferences. We vote what we think would be educational. And sometimes some people vote the way they think the court will go, but we went, our bottom line is 4-2-3, which we think is probably semi-realistic too. And the vote is to affirm, and Justice Crocker has the plurality opinion to affirm.
Thank you, Chief. Yes, we are affirming the judgment of the court below. We believe that the reference to the legislature encompasses, through both the text and the context, encompasses the broader legislative process, which here includes state judicial review, consistent with the state constitution. We believe that the independent state legislature theory should not become the independent state legislature doctrine. And we were also troubled about certain inconsistencies between the possibility of state judicial review here and federal judicial review in this context and in other contexts involving congressional enactments in particular. And so for those reasons, we are voting to affirm today. And I will turn it over.
And then we have a concurrence from Justice Barnes.
This case raises complicated questions, but they're not questions we have to answer today. Two of us believe that North Carolina legislature made it very clear that they expected judicial review. They set up a process for it, and the legislature must live with the consequences of that and what the state Supreme Court decides.
And then finally dissenting is Justice Bravin.
I first have to say that the unprecedented leak of our fake opinion was to say that it disrupted our deliberations would be faking it. We've discussed in the past the anti-commandeering doctrine. But if there is an anti-commandeering doctrine, there must as well be a commandeering doctrine. And we see the intent of the framers when they drew the elections clause to commandeer the state legislature to carry out the functions that Congress itself could carry out. state legislatures much closer to the areas that they oversee than the federal Congress. And so the federal Congress had other things to do, you know, passing alien and sedition acts and whatnot. So they couldn't really involve themselves in these details. In effect, the legislature was serving as a federal contractor of sorts, carrying out this federal function on behalf of the Congress. And just as state courts cannot review decisions made by Raytheon or Northrop, likewise, they should not be entitled to review the decisions of a state legislature, which is not acting as a state lawmaking body, but simply as the servant or commanded by Congress. So for that reason, those of us in the dissent feel that you know, we had a majority until the leak, and now we'll just have to settle for being fodder for dissent.
Well, one last thing I would say is the one thing we all agreed on is that the performance of Luke and Morgan were just so first rate. And thank you again. And thanks. Thank you. And now we're going to go right to you.
If our panelists for the next panel would take the bench without a robe. And then we're just going to do a quick right into the next panel if we can, as quickly as possible.
Yeah.